Your Honor, could you now proceed?
Your Worship, the bench is broken. They won't be able to sit, but the bench is broken. They can sit, Your Worship.
On record, Your Worship. Calling case number TC2/2022, the matter /24, the matter between the state versus Paseka France Musoni, applicant number 1, and Vincent Camilot Baloy, applicant number 2, seated at the Palm Beach Magistrates Court in the District of Plymouth Central. Today's date is the 11th of September 2024. Appearances are the same as before. Matter before court. Okay, Your Worship, please assist. I'm not sure. Proceed. Well, bail on effect.
Good afternoon, Your Worship. Your Worship, this is bail on new fact. But I want to raise technical issues, the question of law. First, Your Worship, that's the first thing that I want to raise. And if the court agrees with our position, then the honors shift to the state. If that fails, Your Worship, then we will deal with our main application, if the court so permit. From the beginning, Your Worship, we said the Schedule 5 while applicants don't agree with it, but that's the Schedule 5, and we believed that the prosecution will be able to do two things, Your Worship. In terms of Section 60, 11 capital A in bracket, A, small brackets, A small in bracket. We say, Your Worship, the prosecution has not provided a certificate or written confirmation regarding Schedule 5 of the Criminal Procedure Act as amended. Therefore, failed in its duty as an officer of the court. Your Worship, we submit that if they cannot produce that certificate, in terms of Section 60, 11, capital A in bracket C, which will be mitigate their failure, Your Worship, they have to adduce evidence to say it is a Schedule 5. We'll argue, Your Worship, that all the offenses the applicant are charged with are not part of the Schedule 5. So in short, they should have been charged with Schedule 1. And if the court will agree with defense on that, that will be a Schedule 1, the onus shift to the state to show why the applicant should not be granted bail. It's important, Your Worship. The state is fully aware of that situation. They are aware that they suppose if any Schedule 5 or Schedule 6, they must provide. Perhaps let me read this section on record, Your Worship. It's 11, Section 60, 11, capital A in bracket, small a in bracket. If the Attorney General intend charging any person with an offense referred to in Schedule 5 or 6, the Attorney General may, irrespective of what charge is noted on the charge sheet, at any time before such person plead to the charge, issue a written confirmation to the effect that he or she intend to charge the accused with an offense referred to in Schedule 5 or 6. Your Worship, if prosecution could not provide that certificate or confirmation, the legislator made it an escape route for the prosecution. And you find it in 11, capital A in bracket, small c in bracket. Whenever the question arises in a bail application or during bail proceeding, whether any person in charge is charged or is to be charged with an offense referred to in Schedule 5 or 6, a written confirmation issued by Attorney General under paragraph A shall upon mere production at such application or proceeding be prima facie proof of the charge to be brought against that person. So if that certificate is not there, Your Worship, they have to lead evidence to say it's a Schedule 5, and at their own peril. Your Worship, before this court, I submit that there is no certificate or written confirmation from the Director of Prosecution or Attorney General, as may be the case. And in that situation, Your Worship, the state has not shown that this is a Schedule 5 offenses. And if Your Worship want me to deal charge by charge, I can do that, Your Worship, to show that this is not a Schedule 5 offenses. Your Worship, what the state provided before this court in terms of their own
Bishop, I'm not too sure what's the purpose of all of this. Isn't, as far as I know, this is an application on, or rather, bail on new facts. So far, my colleague has been addressing the court, trying to disprove the prosecution that this is a Schedule 5. When are we getting to showing that there's new facts, and then these new facts warrant the accused person to be released on bail? This is just prolonging and delaying the process, Your Worship, and it's actually a waste of time. Not unless if Your Worship is of the view that this is indeed necessary, but from the state side, I find it totally unnecessary. This is what my colleague should have raised initially when the matter was for bail application. Now, few weeks later, he brings this up. And in fact, Your Worship, just to state, it was my colleague, as per agreement with the defense, that this is a Schedule 5 application. And the application went its entire process to a point where bail was denied. So now it's not the time now to actually discuss whether this is a Schedule 5 or Schedule 6, and there should be a certificate. That should have been done before. Today is for facts, new facts to be placed for the court to decide whether these are new facts, and if they are new facts, and if there are new facts which are relevant, then do they warrant the accused person, or rather applicant A, applicant 1, and applicant 2 to be released on bail? What my colleague is doing now, I do not understand.
Your Worship, I don't understand what my learned friend is trying to achieve. I have addressed Your Worship to say I'm raising a question of law, and I've shown that he's not objecting, he's not saying it's not a question of law. Now, Your Worship, I've read Section 60, 11A, in bracket, A, in bracket. Clearly, I've shown that the Attorney General at any time can raise this issue, to say that the status of the schedule, and issue that at any time, Your Worship. Now, my brother here, he raised an issue purposely delaying my submission or trying to derail me from my submission. Your Worship, the applicant have a right to the rule of law. This country constitution promotes the rule of law. The law provides some protection that people cannot just be, because somebody think it's a Schedule 6, then he charge them with Schedule 6. Somebody think it's a Schedule 5, he charge them in Schedule 5. The law provides mechanism how to deal with this issue. And the act itself, Your Worship, it respects the Constitution of this country, because the Constitution does not allow a person to remain in detention unnecessarily. Now, Your Worship, I've shown that this particular issue is a new fact on its own, let alone what he's talking about. That's a new fact. That they have not produced a certificate is a new fact, Your Worship. Having said so, Your Worship, is trying to run away from providing the certificate and either lead evidence to prove that yes, it's a Schedule 5 matter. And I've said, Your Worship, before I deal with that, why must I waste court's time to go to new facts when actually it's not a Schedule 5? Your Worship, he alleged that we agreed. And Your Worship, there was no agreement. In the affidavits of the applicants, they have said it is Schedule 5, but they don't agree with that. So that should have been a signal to prosecution to say we need to get a certificate because this issue will be raised again. There is no certificate, Your Worship. If there was, you would have stood up and said there is a certificate, Your Worship, and hand it over to be an exhibit. And the section is very clear. If you produce that certificate, the matter ends there and there. Prima facie, it is a decision of the Director General or the Attorney General that it's a Schedule 5. As we stand here, Your Worship, there is no evidentiary proof that it's a Schedule 5. We cannot take shortcuts. If there is an issue of the law, we must bring it up. And I've made it clear, Your Worship, that if we fail on that part, we will now go to the second issue, presenting you in terms of Section 65, in bracket 2 of the Criminal Procedure Act, that give authority to bring new facts. Why should we waste the court's time if it's not a Schedule 5 and then we deal with Schedule 5 issues? We have wasted so much time for the court. We have wasted so much time for the applicants to sit in prison without being granted bail. Your Worship, if my friend is able to argue against or in support of Schedule 5, then he can argue, Your Worship, and then you make your ruling, and then we proceed.
Excuse the court, Your Worship. Seeing that my colleague needs a certificate, then maybe the matter can be adjourned so that same can be provided to the defense. That will clarify the issue even further beyond any doubt. Therefore, Your Worship, the state humbly implores this court to provide it a chance to go to the DPP, provided with to provide the defense with the certificate that they requested. We do not have it at the moment, Your Worship. We were not aware that such an issue would be raised. We were never initially warned by the defense that such an issue would be raised, and therefore the certificate was not provided to myself or my SPP's, Your Worship, and therefore the state is of the view that postponement, a short adjournment, Your Worship, is suitable for purposes of providing this court with a certificate, Your Worship. However, the state wishes to state that it's rather disingenuous of my colleague to now come today and say there was no agreement. Then why did they go along with bail application on the basis of Schedule 5 if they were not in agreement that it is a Schedule 5 offense, Your Worship? And it's not a new matter, it's not a new fact, Your Worship. This is, if at all they knew this, they knew it before. So you can't say something that you knew before and never raised it before and you raise it now. It's a new fact. It's not a new fact. But, Your Worship, if my colleague wishes for the state to provide the defense with a certificate, Your Worship, the state will be left with no choice but to ask for a postponement, Your Worship. The state does not know for how long will that certificate be will it take for it to be provided, Your Worship. Please, Doctor. No, Your Worship. Yes. It's not a, Your Worship. Your Worship, the section says the Attorney General, rather being saying, to put it differently, the DPP, Director of Public Prosecution, may issue a certificate. May, not shall, issue a certificate. However, seeing that my colleague is impressing upon this issue and is being emphatic so much that the state is of the view that to clarify issues conclusively, then we need an adjournment to provide him with conclusive evidence coming from the TPP that this is a Schedule 5 matter, Yoshi. The state was under the impression that today things will proceed. However, if my colleague wishes for the state to request for an adjournment, Your Worship, the state will be left with no choice but to request for an adjournment. But I do acknowledge the Director of Public Prosecution is not obliged, may, not shall, provide the certificate.
A and C.
There's no A, it's B and C.
Yes, the
A
A.
says A, C says shall.
Yes.
Not right.
Yes.
Yes. A, capital letter, small letter A said, if the Attorney General intends charging any person with an offense referred to in Schedule 5 or 6, the Attorney General may, irrespective of what charge is noted in the charge sheet, at any time before such person pleads to the charge, issue a written confirmation to the effect that he or she intends to charge the accused with an offense referred to in Schedule 5 or 5 or 6. In the state's understanding, see, whenever the question arises in a bail application or during bail proceedings, whether any person is charged or is to be charged with an offense referred to in Schedule 5 or 6, written confirmation issued by the Attorney General under paragraph A shall, upon its mere production at any such application, be prima facie proof of the charge. Shall, yes, if that evidence, if that certificate is there, if the Attorney General has decided, has used his discretion to provide with the certificate, if it's there in the state's possession, mere production thereof shall be conclusive proof. However, current paragraph A says may, not shall. So that Attorney General is not obliged to provide with the certificate. That's the state's submission. However, if the defense wants the certificate, the state is asking for a postponement, Your Worship, to provide it with the said certificate.
Thank you, Worship. The section is very clear. Your Worship, I read the two sections. The first one, may, and if the DPP, is that I'm correct? Oh, I'll stick to Attorney General, what is written here. If the Attorney General may issue at any time, it tells your Worship that the charge to go to that stage, it must be approved by the Attorney General. And if that's not the case, your Worship, 60, capital A in bracket, C, small c in bracket, comes up, your Worship, with a situation that the prosecution must prove whether it is Schedule 5 or not, your Worship. Now, my friend wants to resort to the old tactics of postponement. Those are old tactics. The issue is that he could put the witness there on the box and state how did he come to say it is Schedule 5. That's the cure. Your Worship, I'm saying this, your Worship, very clearly, because the Constitution protects any person who's charged for an offense. Offenses, your Worship, are clearly defined. Now you can't tell me, oh, I'm sorry, your Worship, I'm saying he can't tell me that a dummy, what's the correct word? This one.
It's a replica.
A replica AK-47 sold in many shops in around Johannesburg. It's a Schedule 5 offense. He can't tell me that, your Worship. He can't tell me when a person taking his children from school is a Schedule 5 offense. Your Worship, if I refer you to the affidavit by the police officer, he referred to the weapon as, and it does not describe the weapon effectively. What is the rifle? What are the serial number of that rifle? Are they still there or interfered with? He just tell us one thing, the reference to he tell us about the reference where the matter but he just gives the reference where they've taken the vehicle for ballistics. It doesn't work like that, your Worship. He must give the type of a weapon that we are talking about to qualify that weapon as a Schedule 5. Your Worship, if they were sure about the type of weapon they are talking about, they would have given the court exactly what the weapon it is. Your Worship, I've introduced that, your Worship, and just to show you that they have a case to justify, to say it's a Schedule 5. And, your Worship, as we stand here, this court has been misled in many ways. First, kidnapping. The court has been misled with kidnapping. Your Worship, in this court, prosecution on record said they have a certificate, a court order that granted the mother of the grandmother of the children parental rights. Your Worship, there's nothing like that. There is no such court order. They are misleading the court. J50. People arrested at the police station. What is the need of a J50 when people are already at the police station? Another way of misleading this court. Your Worship, I have said, I'm putting this aspect, there is no reason for postponement. The Act provides a mechanism to cure that part. If the Attorney General, as my learned friend has confirmed that he has not done so, there is the place. You must put their witness there to tell us how did he come to Schedule 5. Then we have the opportunity to cross-examine that witness at their own peril. Now they are running for the reality. They want us to give time to go to the Attorney General and say we are asking, why didn't they ask about this thing? From the beginning of the bail application, we have raised that we are not in agreement with the Schedule 5. Now we have find new evidence that is not the Schedule 5. Your Worship, a Schedule 5 semi-automatic rifle. They don't say what type of a rifle. They talk about bullets, but the accused are not charged of ammunition. Talk about ammunition, a rifle and ammunition, but the witnesses are not, or the applicant are not charged with the ammunition. All those things are misleading the court. The court should be independent. And next thing they will come and say the court is biased. We have not complained about the court. We have not raised a single issue when the court went against us. The Victorians are going to complain about the court. Your Worship, this is a point that this court, not tomorrow, not after break, not after adjournment, the evidence is before court. There is no certificate. If we can't lead evidence, the court will have to take our uncontested submission, Your Worship. It's not contested up to now. The court cannot keep on giving them the opportunity to do as they like. Your Worship, let me stop there and allow the court to make its own decision. Yes. Thank you, Worship. Yeah. Your Worship, I want first to present a copy of the receipt where the alleged rifle was bought. So it's written, clearly written, Your Worship, it's not Are you getting that document? Indulgence worship. Your Worship, a receipt has been obtained showing where this particular alleged AK-47 was bought. Walking customer. Your Worship, shop number 290, China Mall, Amalgam, Johannesburg. That is Your Worship, I just want to give my friend first copies of it before I hand over.
And Your Worship, if I may, another thing, Your Worship, the state is not in possession of this affidavit that's now being handed in as annexures, or a portion thereof is being handed in as evidence. And what evidence is this? Is this now substantiating the fact that there's new evidence? Your Worship, the state is confused as to the procedure going on. It just doesn't make sense. What's my colleague trying to get at? The schedule.
The issue of the schedule.
But then didn't Your Worship say that my colleague should each count, as he said, that
I'm doing that.
every count does not have a Schedule 5 attached to it? Shouldn't he just go each count instead of showing us slips and receipts of things we don't know about? We don't have any affidavit. We've been asking for this affidavit for a few days. We don't have this affidavit. I don't know what they given to the court.
You were given this thing.
Given the affidavit.
We're
Sir,
not talking about affidavit,
sir,
we're
I'm standing.
talking about evidence. Yes, that's why I started. You are correct, Your Worship. No problem, Your Worship. I wanted to, let me start with count 5.1 in their own document. Because we don't have a charge sheet, Your Worship, will rely on what they put in here. Your Worship, times 2 kidnapping of involving of the Katlehong North affidavit, Your Worship. They are affidavit. That's page 2, Your Worship. Times 2 kidnapping involving 2 kids. Your Worship, in terms of schedule, kidnap is not a Schedule 5. But let's leave that, Your Worship. This court had the opportunity to hear whose children are those. And this court came to the conclusion that the father of the children should be released because there was no dispute between defense and the prosecution. There is no dispute about whose children are there. Now kidnapping, Your Worship, has no basis. It's weak. It cannot stand. And when I go on, Your Worship, the Children's Court has already dealt with this aspect. And they have said the father must retain the 2 children and the grandmother, maternal side, must retain the other 2 children until the court so decides. So I don't see how such a situation where family fight tend to be Schedule 5 with no death, no serious injuries, how it tend to be Schedule 5. Your Worship, I won't spend too much on that, but I've just given you a signal to that. Intimidation, not less than 3 counts. Your Worship, intimidation is not a Schedule 5. Your Worship, let me put these words in front so that I must not forget that in all these charges, if a person has never been found guilty on them, it cannot be a Schedule 5. Let's go to 5.3, trespassing. Your Worship, trespassing cannot be a Schedule 5. Cannot be. And it's worse, a public place where a parent go pick up his own children. That charge is weak, Your Worship. In actual fact, it's just abusing the court system. 5.4, contravention of Section 123B of Firearm Control Act 60 of 2000, failure to produce license for firearm when so requested. It's not a Schedule 5. Failure to produce a license. Can it be a Schedule 5? No, it cannot, Your Worship. I move, Your Worship, to 5.5, contravention of Section 21A. I'll come back, Your Worship, to 5.4. Contravention of Section 20 in bracket 1 and bracket A of PSIRA, working as a security without documents. It's not a Schedule 5. There is no Schedule 5 there. Let me continue, Your Worship. 5.6, discharge of firearm in a building area. It's not a Schedule 5, Your Worship. I don't want to go into the merits, Your Worship, but it's not a Schedule 5. 2 times assault. It's not a Schedule 5, Your Worship. Pointing of a firearm, Your Worship, is not a Schedule 5. In fact, I will argue there was no firearm. Possession of unlicensed firearm, a rifle, That's where, Your Worship, I want to spend some little time, Your Worship, to say this rifle they are talking about, Your Worship, is something that you buy over the counter. It's a replica. And they are so brave enough not to tell the court that we suspect it could be a replica. If they had said so, Your Worship, they would have at least taken the court into their confidence. Your Worship, I have original receipt, which I intend handing over, Your Worship, and a picture of this replica, Your Worship, which was taken at the police station. What is even worse, it was taken at the police station to show that it's a replica. That's why even police at the police station could not bother about where it's left, because it's a replica. If it was a serious weapon, it would have never been taken like this. Here in the picture, you'll see there are replica bullet or ammunition. They are not charged of that because they know exactly that it is not a firearm, Your Worship. And I'm saying this, Your Worship, to say that if police cannot come to court and assist the court to come to the correct conclusion, and they are misleading the court. Your Worship, I want to say at the beginning, I have said that the prosecution is not a rubber stamp of the police. They must do their job. And it seems as if they are a rubber stamp, as we, in this particular situation, Your Worship. I have an official receipt of purchase of that weapon, clearly described. And then I have a picture, Your Worship, from taken at the police station, Your Worship. Show the type of weapon with the writing showing it's not a proper weapon. That's why, Your Worship, I'm saying if the investigating officer had done his work, he will have written the serial number of the weapon. He will have described the weapon as the automatic or semi-automatic or an ordinary rifle. He doesn't give the court that information for the court to be able to make a correct decision. Weapon, Your Worship, automatic weapon, Your Worship, is a Schedule 5. But they are not telling the court what is the type of weapon. And if they don't say we take it as an ordinary rifle, even if it was the real weapon, Your Worship, it will still not be a Schedule 5 because it's not automatic. And they have not alleged it's an automatic. Your Worship, clearly, the police at Katlehong were not stupid. They were not stupid, Your Worship. The investigating officer cannot describe the police at Katlehong to be stupid, to leave a replica in the table like this, or a live weapon in the table like this. You won't do that. As soon as the police are convinced it's a replica, they are able to put it on the table, take pictures, and they show even those cartridges there, which is not a real ammunition, Your Worship. And the police in their own statement, they don't write in their own charges, they don't write about ammunition. They are charging him of weapon, a rifle, but they don't talk about ammunition. But in their report, they talk about ammunition. Where did this ammunition come from? Your Worship, let me move. I've already displayed. If Your Worship I would have loved to hand over this. Yes, I'll make a stitch. Your Worship, I'm giving the original receipt. No, we have given the state copies. .10, Your Worship. 5.10, Your Worship. Possession of dangerous weapon, 2 pangas. Your Worship, that's not a Schedule 5. Possession is not a Schedule 5. Malicious damage to property, vehicle belong to maternal family, witness. That's not a Schedule 5, Your Worship. The state has not alleged before court that any of the accused or the applicant has been found guilty on any of these charges. Thus, make it a Schedule 5. They have not done that, Your Worship. Your Worship, I have mentioned that I'll go back to 5.4, contravention of Section 123B of the Firearm Control Act, failure to produce license. If we are talking about the rifle, Your Worship, it does not need a license. So it is not a Schedule 5. It seems as if my learned friend, investigator, wanted to please the public in keeping the most famous prophet in prison. There is nothing that makes them to keep him in prison. Your Worship, that's not a Schedule 5, and the prosecutor knows that. That is not a Schedule 5. You have a right, my friend, to stop me if I'm moving fast. Okay. That I put our case across, Your Worship.
Worship? Yes. So Your Worship, I don't know if I'm assuming my colleague is saying this copy of a receipt relates to the firearm that was seen in the video. I don't know what's this receipt is pertaining to what exactly, because if my colleague says this receipt pertains to the firearm that was seen in the video, which was in the possession of accused number 2, then how can we actually determine that this relates to that firearm? Because that firearm has a serial number, Yoshi. That if he calls it a replica, whatever it is, it has a serial number. And this receipt does not display any serial number which links this receipt to that firearm. Now, in the state's view, this receipt proves nothing. This could be a receipt for any other gun held by any other, or rather any other, it's written here, blank gun. This could be a receipt for any other blank gun which is held by any other person and which could not have been or which might not have been this, the blank, supposedly, as my colleague says, it's a blank gun, which was held by applicant number 2. So this proves nothing. This proves absolutely nothing. And furthermore, Your Worship, the state's view, the evidence, I don't know whether my colleague remembers very well that when I was reading the affidavit by the state in opposition to bail, we mentioned that there were two rifles at the scene. There were 2 rifles. This is a slip. This is well, I don't know what it is. I'll call it a receipt. It's a receipt for 1 rifle, 1 blank gun. It does not specify which gun exactly. And whereas the state did mention in its evidence during the bail application that there were 2 guns at the scene. At one point, applicant number 1 opened the boot of his vehicle and he took out what appears to have been a rifle and he fired shots with it. Now, if maybe my colleague wishes to prove that both guns were not real, then come with both receipts, and both receipts ought to have some serial number indicates that this is a receipt in relation to this firearm. That doesn't show in this this paper that's before me. And this picture, I don't know. Okay, fine. I don't know what gun is this. My colleague says it comes from the police station. Maybe it's Your Worship's prerogative, Your Worship, to accept evidence, whichever evidence Your Worship during bail applications. But the state is of the view that this doesn't show which firearm is this. I have no clue, Your Worship. And furthermore, we've not been provided with these affidavits that are now being disentangled and submitted piecemeal to the court as exhibits. We are before court today, Your Worship, as the state, after been requesting the defense's affidavit, or rather the applicant's affidavit, several times to no avail, so that same can be properly perused by the defense, by the state, to determine whether indeed there are new facts to justify the accused person to be released on bail. But we haven't yet received such an affidavit, Your Worship. And we come before this court today under the pretext by my colleague that they will be bringing bail on new facts. But now they saying they're bringing a technical point first before bail. The state is of the view that this is just another way of bringing not new facts into consideration by the court in deciding whether the accused person ought to be released on bail or new facts. This, if they've had this, and I heard my colleague saying the fact that it is not a real gun, that in itself is a new fact. But, Your Worship, this let's assume then, okay, fine, it was not a real gun. That's a fact that was available to them. It was available to them. That fact was not used in their first bail application. That fact could have been used in the first bail application to indicate that the state does not have a strong case with regards to the 4th count, indicate that they have the accused persons have been found with a rifle, a real rifle. They didn't. That was available. So to use that, an available fact, as in a bail on new facts application, and not say no, we're using this as part of the new facts. No, but then we're using this or on the basis of a technical issue first before we delve into the bail in new facts. That's disguising what they're actually trying to do, Your Worship. And the state is strongly opposed to the manner in which the defense is going about this proceedings, Your Worship. They treated, in the state's view, they were confusing proceedings. It became just a confusion, but Your Worship did clarify that it's a point in limine, and the state will accept Your Worship's clarification. But having said that, Your Worship, we still maintain that this receipt says nothing. This picture says nothing. This receipt, ordinarily, if it ought to have, because the gun, be it a blank gun, a replica, has a serial number. And the receipt in relation to that purchase ought to have a serial number indicating to which purchase does that receipt relate to. This is nothing, Your Worship. And therefore, Your Worship, the state is of the view that it is a Schedule 5 offense. There's 2 rifles. My colleague has been arguing on and on about 1 rifle, which he submits that what he gave to this court is proof that it wasn't actually a rifle, but a replica. But the state submits that there's 2, and the other one is still was not given by the first applicant. The other one is still in the, not in possession, physical possession of the first applicant, but he knows where it is. And the state is of the view that which we saw on video, which was fired in public, is a rifle, Your Worship. And therefore, the Schedule 4, or rather I believe it's the 4th count. The 4th count makes this matter to be a Schedule 5, in that the state has seen in the videos that accused person was firing a rifle, and furthermore, this does not prove that what the accused person had on the day was not a rifle. This proves nothing. This shows whatever. I don't know what it proves, Your Worship. It's just a receipt. So, Your Worship, I don't know. Are we still going to go to... But we leave it in the court's hands, Your Worship, seeing that my colleague was addressing a point in limine for Your Worship to come to a judicial decision in this regard. Is it please?
Thank you, Worship. The state has not addressed the issue. Let me say all the issues. They just stick to a rifle, Your Worship. I have argued, Your Worship, that even if it was a rifle, they have not alleged it was an automatic rifle, right? That's number one. Let's say they talk about it is not a replica, Your Worship. They suppose the state supposed to have given a serial number of that rifle. Your Worship, every weapon, a firearm, not talking about replica, Your Worship, every firearm has serial number. I have said, Your Worship, the state has failed. They have failed to put in their affidavit the serial number. If serial number have been interfered with, rubbed off, the state must say the serial number has been rubbed off, and thus the weapon is sent for ballistics. Here they give us a reference of ballistic. Using the same argument, any gun that they would have taken for ballistic would be the same situation. Here, Your Worship, there is nothing in law that says a replica must have serial number. He has not shown that. A replica is a replica. It's not a real gun. That's why on it, Your Worship, you'll see on that picture there are white things that are written there, which is warn that is not a real gun. A military man like myself, Your Worship, will see it that this is not a real gun. Now the danger of it, Your Worship, of that, it is a danger to the carrier. The hold of that gun is a danger, because if I'm not aware it's not a real gun, I may shoot him. So the danger is not on the public, it's on the same person who's holding that weapon. Now he comes in, he argues to say, no, they are two rifles. There is no evidence before this court to show that really there is the second rifle. It's just a hearsay misleading the court. In fact, this prosecution, Your Worship, not once has misled this court. They have come to court and say, when we say these are the third accused is the parent of the two children, the holder of the rights. And they said, no, we've got a temporary or court order, interim court order that granted their granny a right to the children, which is not true, Your Worship. So if they are so much damned to mislead the court, I'm sorry, Your Worship, they are the officers of this court. They're supposed to tell this court nothing else but the truth. They must assist this court to come to the correct conclusion, not what they want. Your Worship, when they talk about second rifle, it's very interesting. The applicant were at the police station. All the tools that they found, the weapons they found them at the police station. Now, where does the second rifle come from? If he talks about a video, he should have shown us the video that there is really a second a rifle. Now they come up and speculate, say there is a second rifle. It's an embarrassment to both the police and prosecution, who is allowed to be used as a rubber stamp of the police. It's an embarrassment, Your Worship. Here I was expecting my learned friend to say, yes, a rifle is a Schedule 5, and then he support his statement. Where does he get that a rifle is a Schedule 5? If the rifle is being used in robbery, yes, Your Worship. If the rifle is used in murder, yes, Your Worship. But not just a rifle and then you say it's a Schedule 5. I have put it, Your Worship, to say this is a replica. But again, Your Worship, I have argued in terms of the real rifle is not a Schedule 5. And they have not contested my argument, Your Worship. As we stand now, they have not contradicted whatever I've said is not a Schedule 5. Your Worship, we will leave it to court to make its own decision. Thank you.
In this one. Reserve. Okay, we can swear him in, Your Worship, and lead evidence.
With that, we class, I was also missing working with everyone on our Shamsa for a level for participation. You can have Popo, your local Laka baby, Mabapina, for that, in Kata, I come with Lukisa, and Mabapin as scheduled Samira during Cosanona. Washalosa for a Bukuela, Bukalo, Musikisi. Hake at least a certificate kgotsa tokomane e netefatsang gore melato e tshwanela ke Schedule 5. Schedule 5 e tlhalosa gore ba mosebetsi wa lona jaaka batlosiwa o bontsha gore tsamaiso ya toka e dumela jwang tokolo ya yona le gape wa tlhalosa gore ka lebaka la gore ga ba tlisa ditokomane tse e bontshang gore melato e tlosang yona ke Schedule 5 e go tla tshwanela go iqhosa kgotsa go lesekisa melato ena ka tlasa Schedule 5 go palo go tla le fetile Schedule 5 le tse Schedule 1. Schedule 1 se tlhalosa gore tla ba mosebetsi wa mosekisi fana ka mabaka a bontshang go baneng le go tla le sa tshwanela go dumela toko ya lona ya pedi le gape a ba tswela pele gore lona jaaka baqhosiwa le na ditokelo tse di tshireletsang tse tlasa molaotheo le gape ba tlhalosa gore go tloa boqalo ga ba nke ba dumela gore melato ena ke ya Schedule 5 le gape wa tlhalosa gore ya ba ne ba hloleha go bontsha ka bopaki gore melato ena se ya Schedule 5 ba tla tswela pele ka kopo ya rona ya go lokola ka pele mabapi a dintlha tse dintšha le gape wa tlhalosa gore o kgatlanong le gore mosekisi molato ona o busetse morago empa o bona go le botoka gore mosekisi ena a tlise mopaki a tla kena mona mo lekgotleng a tlhalose ka botlalo gore molato ona e ba Schedule 5 ka mabaka a feng kgotsa ka bopaki bo feng a ba tswela pele mabapi a dikulo le sethunya ba tlhalosa gore e ka se nne Schedule 5 gobane a gona ballistic report ke pele e tlaya gobane ba sebetsa ka go tlhatlhoba ka dithunya e leng ya tlhalosa gore sethunya se fumaneng kgotsa dithunya ke tsa mofuta ofe le gape wa tlhalosa gore mosekisi mabapi a melato ba tlhosang yona ga ke ba bua nnete gagolo hampe ka taba ya kidnapping le gape o la tlhalosa gore mosekisi o la bua maaka a bua a re go na le lekwalo le le lantshwang ke lekgotla le le lenafang kgono wa bana tokelo ya gore a tlhokomele bana le gape wa tlhalosa gore mabapi a taba ya J50 a se nnete gobane lona jaaka baqhosiwa le fumane le le police station ditšhankaneng le gape wa tlhalosa gore ba tshwanetse ba ditse mopaki o tlo tlhalosa gore melato yona e ba Schedule 5 jwang le gape wa tlhalosa gore gobaneng ntse ba tswela pele ba bua ka melato e le qhosang yona ya go tshwara dikulo gobaneng ga la qhosa yona melato eo le gape wa tlhalosa gore melato e meng e le qhosang yona e kgatlanong le ditokelo tsa lona a ba kena ka botlalo mabapi a melato e le qhosang yona a re la ntlha molato wa ntlha wa tshwara sethunya se se tlasa molao o tshwere yena receipt kgotsa tokomane e bontshang gore sethunya seo kgotsa rifle AK47 ile ya rekwa ko 290 China Mall Amakamko Johannesburg e le lebitso la lebetlele leo le gape ba tlhalosa gore melato e mebedi le qhosang yona ya go kidnapa kgotsa ya go kwetela ya bana ba babedi e ka se be Schedule 5 gobane ile wa tlhalosa gore moqhosi wa boraro ke yena ntate wa bana o na le tokelo ya go tlhokomela bana ke ka hoo moatlhodi o le a mo lokolla kgotsa a dumela kopo ya hae ya go lokolla ka pedi le gape wa tlhalosa gore molato wa go tshosetsa e ka se be Schedule 5 ga baneng ga sokwa wa tliswa bopaki bo bontshang gore motho la fumana ana le molato mabapi le molato o tshwanang le o le hape molato wa trespassing kgotsa o kena pihing kgotsa thipeng ya motho o sena tokelo ka se be schedule 5 hobane lefelo leo mo neketsahalo e etsala teng ke lefelo le dumeletseng mongwe le mongwe wa setjhaba jwale ka se be trespassing le hape wa hlalosa hore molato o mong o wa tshwara sethunya gantle le tokomane kgotsa license e ka se le schedule 5 hobane rifle a tlhoke gore motho a be le license gore a tshware le hape rifle eo le se rifle ya mannete le sethunya se tshwanang le rifle le hape wa hlalosa gore o sebetsa jaaka modisi o sena ditokomane le yona molato ba o qhosang ona ka se schedule 5 o thunya ha se thunya mo pela ga setšhaba le yona ka se schedule 5 molato wa hlasetsa lebedi le qhosang yona le yona ka se schedule 5 le hape o supa motho ka sethunya ka se schedule 5 hobane no sena sethunya se leng sa bontsha gore motho la supa ka sethunya le hape wa hlalosa gore molato le qhosang ona wa o tshwara sethunya ho sena license e leng rifle ka se be schedule 5 hobane o tlise tokomane kgotsa receipt e bontshang gore rifle eo ne se rifle ya mannete le hape molato le qhosang ona wa o tshwara dipulo ka se schedule 5 hobane tokomane ya tlisitseng e bontshitse gore sethunya seo a se sa mannete le dikulo tsa tsona a se tsa mannete le hape wa hlalosa gore o tlile ka senepe se hlaya mane police station se bontshang gore sethunya seo ne se sa mannete le hape ne se sena serial number e bontshang gore ke sethunya sa mannete le hape le molato mong o qhosang ona wa o thuba thipa kgotsa malicious injury to property le yona ka se be schedule 5 le hape le bonisa le etsang dipatlisiso le batla o senya lebitso hobane ngwana o le moruti yo o tsebehang le hape a o senya lebitso ka gore o dule ditjhankaneng a o kenetse mahlo a batho a ba tsela pele a hlalosa ka boqetelong gore sethunya se buang ka sona sa bobedi se ko kae le hape ke ka lebaka le etsang gore se sa fumana ko police station ke eng le hape video e mosekisi a buang ka yona ke ko kae hobane e sa tliswa jaaka bopaki mona le hape wa hlalosa gore sethunya seo ha ebane ne se sebediswa ho tshwara poho kgotsa bolaya motho mong ana tla hlalohanya hobane molatona ba o qosa ona e ba schedule 5 ke sene se bua ke moeledi wa lona seo ke tla kena ko sene se bua ke mosekisi la ntlha o la qala gore a hlalosa gore moeledi wa lona o senyatsa nako ka ditlhatsa di buang go bana ka le kopantshang ka jeno ke gore re tlomamela kopo ya lona ya lokola ka pedi le hape wa hlalosa gore ditlhatsena tsohle ke o senya nako le go tshwarella le hape wa hlalosa gore ditlhatsena ne ba tshwanetse be ba di buile a ne dipusano tsena di qala gore ba kgatlanong le schedule gore se schedule 5 le hape wa hlalosa gore ba ile ba dumela gore ke schedule 5 o fitlela ba tle ba fetse le kopo ya lona ya ntlha ya lokola ka pedi o fitlela ebe e hanetswa le hape le baka le re kopantshang ke gore moeledi wa lona a tlise dintlha tse dintšha tse tla go tsofatsang le gotla gore go baneng ba tshwanetse ba dumelle gore le lokolo ka pele a ba tswela pele gore ha baneng ka nnete ba batla tokomane e bontshang gore molatona kwa schedule 5 o tla kopa molato o go tlisetsa morao gore a kgone ho buisana le baeteledipele ba hae kgotsa basekisi ba baholo ba kgone ho mo thusa ka tokomane e tla bontshang gore molato ona ka nnete ke wa schedule 5 le hape wa hlalosa gore dintlha tsohle tse ba di buileng ke moeledi wa lona se dintlha tse dintšha le hape wa hlalosa gore ha baneng ba ntse ba netefatsa gore ba batla certificate se bontshang gore ke schedule 5 ba tla kopa gore molato o busetse morao le hape ka se tsebe gore o tla hloka nako e kakanang ba hlalosa gore la bofelo gore receipt ba itlisitseng ha ba tsebe gore ke a sethunya sefe le hape wa hlalosa gore sethunya sile sa bontsha gore sena le serial number le hape ke sethunya se ba se fumaneng ko moqosuweng wa bobedi le hape wa hlalosa gore gona le molato gona le sethunya se seng se senyamaletseng se go sa tsebeng gore se ko kae le hape wa hlalosa gore receipt eo a netefatse gore e bua ka sethunya se feng ka nna receipt ya sethunya se feng le se feng le hape wa hlalosa gore receipt eo e bontsha fela mabaping a sethunya se senotshi empa o na le dithunya tse pedi o lefileng la ketsahalo eo le hape la hlalosa gore receipt eo I specify kgotsa e netefatse gore e bua ka sethunya se feng mo molatong ona le hape moledi wa lona o ntse tswela pele a bala di-affidavit kgotsa maikwalo a boikanyo e ya bona ba slang bona le hape a ba fumana monyetla wa bala makolo ao o netefatsa gore dintlha tse di tlisitseng ke dintlha tse dintšha mabaping a kopo ya lona ya lokola ka beili le hape e ka se le ntlha e ntšha gobane di gale ne ba tseba gore sethunya seo ga se sa nnete go tloa dipuisano tsena be di qala a se ntlha e ba simolotseng o e fumana ka jeno le hape wa hlalosa gore a dumelane kgotsa o kgatlanong le mokgwa o moeledi wa lona o sebetsang ka ona kgotsa o etsang dintho ka ona le gape wa hlalosa ka botlalo gore receipt e tlisitseng a e tlise bopaki ba se ke se ne se bua ke moeledi le mosekisi wa lona understood.
After your worship, my sheet is first with MMAISIEA. Surname is Swipe, spells with NGWEPA. Thank you, worship. I'll conduct my testimony in English, worship. No objection. So help me God.
Where are you employed?
In the SAPS.
How long have you been employed?
22 years. 22 years service, worship.
What's your rank?
I'm currently a captain in the police, worship.
Which division or station or department?
I'm based at SAPS district, Ekurhuleni.
And then this the case relating to applicant 1 and applicant 2, the criminal case, are you aware of it?
I am, your worship.
How are you aware and involved in it?
The matter was allocated to me immediately after the incident, your worship, to investigate.
And so you're the investigating officer?
I am, your worship.
Investigations finalized?
Not yet, your worship. We're still waiting for the video in question, your worship, that was downloaded at the school. We sent it to cybercrime for them to do analysis for us. And the SCP-69 as well is outstanding.
So, as an investigating officer, you are aware of what transpired on the 5th of August 2024 in relation to accused number 1, 2. There was a third accused, there was applicant 1 and 2 today. How many videos do you have during this investigation?
It's one video, your worship, that was downloaded from the school CCTV footage.
And then in that video, can you just briefly tell us did you have sight of the video?
Yes, I did immediately after the first appearance of both accused before this honorable court.
And then what did you observe when you had sight of the video?
Yeah, I went to school after the appearance, and I viewed the footage there in the presence of the headmaster of the school. What I've seen there, it's from the gate, your worship, there was a black BMW and a white vehicle and the other vehicle across the road. And I saw accused number 1 and number 2 before this honorable court coming in. Accused number 1 was having 2 pangas and number 2 was in possession of the rifle in question. Your Worship. And there was fight inside the school staff rooms there, where accused number 3 was locked in the butler door that goes through the passage. But finally, when accused number 1 was fighting there, he managed to give accused number 3 a panga to open the forced entry, to open the door. And they managed to come out, and he was like paving people who were in front of him with the panga. And when they leave the gate, there were people who were passing by who were actually disturbing him to get into his BMW. And the accused number 2 was in possession of the rifle. And accused number 1 went into his BMW vehicle. He came back with another rifle and he fired 1 shot. That's why he dispersed the crowd. And they managed to get into this BMW and the other one into that other vehicle. It was the driver of that vehicle and the guy who was carrying the 2 kids with him.
And then in your investigation, I see that you mentioned several weapons. Were there any weapons recovered during the investigation and so forth?
Not. It's only the rifle and the 2 pangas that were not recovered but handed to the police. But this other rifle that was used to fire a shot was not recovered.
And then, so how do you know from your investigation and what's seen in the video, how do you know which rifle is which? You've seen that there's 2 rifles and you mentioned that the other one was in the boot and the other one was carried by the second applicant. How do you know which one is which?
I cannot tell as to whether the one-handed is the one that was used by accused number 1 or is the one that was in possession of accused number 2. That I cannot tell.
And then as a police officer, do you have any form of experience relating to firearms and so forth?
That is why I took it to ballistic, because I knew I'm not a ballistic expert. But what I can tell you is a replica is an imitation of certain firearm, and a replica is not a toy. And what you are talking about there, it has, a replica cannot have, a toy cannot have the so-called trigger. A toy cannot have a barrel. But I don't want to go in details into that. I think it's wise enough maybe for the court to invite a ballistic expert to come and give. But the little I know is a replica is not a toy. That is why it has a barrel, it has a trigger that you can pull and it will discharge.
So you say the accused person, accused number 2, or rather the first applicant, sorry. The first applicant in the video was firing shots with what would appear as handgun or rifle, or what type of gun in your view?
It's a rifle. It looks exactly like the one that was handed into the police.
And from what you see, would you say well, maybe you can't tell, but in your view, would you say was it a replica or a real gun or what?
The one that was in possession of accused number 1.
No, I'm saying yes, the one that was used to fire shots.
Look, even this one that you're talking about now, if you see it, or if one point you with, or if you see somebody carrying that, you cannot say this is a replica. That is why people are all over the place. So even that one, I cannot tell as to whether it's a replica or it's a real firearm up until recovered and tested.
So far, the other firearm, it hasn't been recovered?
It's only this rifle that we're talking about, and other firearm was not recovered.
And the one that you have, in relation to ballistic reports and so forth, investigations finalized in that regard?
Yeah, it is. We're in possession of the report.
Okay. And then, does it have a serial number?
It does.
And is it a real gun or replica?
You know, let's read that report if the court permits.
No, but I'm asking you, sir. Or you're not into...
I don't. This real gun, like I said to you, replica is not a toy. So if you're saying to me, is it a
Okay,
real
no,
gun?
please,
I
yes.
have a problem with that one.
Okay. So is it a replica or is it a what sort of gun is it?
That's what I'm saying. If the court permits, let's just read that one line that identify the fire.
Okay. You mentioned you mean the 2 and 2 still.
Yes, I am.
Bishop, with the permission of the court.
We have no objection, Your Worship. We have to object this.
No objection, Your Worship.
Can I, with your permission, Your Worship? Okay, it's point 3.1. I'll start where they are talking specifically about the firearm, Your Worship. It says it's 9mm PAK caliber. I can't read this English. It says the Clio model AK9 fully automatic blank rifle, blank firing assault rifle with serial number so. I'm not sure if. Let me repeat it, Your Worship. It says 9mm PAK caliber, the Clio model AK9 fully automatic blank firing assault rifle with the following serial numbers.
So, sir, in your view, if a person uses that, the rifle that you managed to secure into his position, they use it at a person, can it cause damage?
Yeah, if it's at close range, definitely it will cause a damage.
Would that damage be fatal?
Yeah, I mean it sparks the fire. If it can damage your eyes. Let me give you an example. You can be blind if it's fired very close to your face.
And you say the other one, you're not sure, you don't know where it is, and it hasn't been located, correct?
Correct.
Is there anything further that you think we should address to the court regarding the specific issue that's of one of contention?
Yeah, I want to say before this honorable court that the vehicle used when I arrived at Katlehong North Police Station, they were all not there. All the vehicle that was used in the commission of the crime, they were all not there. And I interviewed witnesses, and there are witnesses who were like pointed with a pistol, not a rifle, by accused number 1. And when I check with firearm registry, with accused number 1's ID, I've established that he's owning 2 licensed firearms. So that's all what I wanted to put before this honorable court.
Yes, concluded.
ke sene se bua ke bopaki bo ntate wa hlalosa gore o sebetsa ko SAPS o na le jara tse 22 a sebetsa jaaka captain o sebetsa ko SAPS ya ko Ekhobuleni la pula botsa go wa tseba ka molato ena o lithosa bona ba wa tseba hape ke na etsa dipatlisiso le hape dipatlisiso di sofele ba ne sentse na shota ka video ya mane ko sekolong le SAP 69 ke le kwalo le hlang sepoliseng le hlalosang gore ana lona jaaka ba qosuwa le na le melato ya gale kgotsa dikatlo tsa gale pele go tla molao le hape wa hlalosa go wa tseba ke tsa halo le ya etsa ka di 5 tsa August 2024 mabapi a molato qosa bona jaaka lona ba qosuwa ba bararo le hape wa hlalosa gore o la botswa ka di video ba hlalosa le video e notsi e ya ntsa dipatlisiso ka yona e ya tshwanetseng a inka mane sekolong mo petsahalo e le ya etsa la teng le hape o la botsa gore video e bonene ba hlalosa gore e bone pela ga morao wa gore bona ba qosuwa le hlaile hlantlha mo pela le khotla le hape wa hlalosa gore ile ya mane sekolong a le sheba le principal wa ko sekolong le hape se a se bone gore mo hekeng ona na le koloi tse pedi BMW e koloi e nngwe e sweu le hape o bone moqosuwa wa ntlha le wa bobedi ba kena le hape moqosuwa wa ntlha ana tshwere diphanga tse pedi moqosuwa mobedi a tshwere rifle le hape wa hlalosa lona le ntwa ka mogare ga sekolo mone moqosuwa boraro yena o ile nga lokollwa ba mo kwalletse morao ha batla ke mo he moqosuwa wa ntlha a fa moqosuwa boraro phanga gore a robe batla a gone go tswa le hape ba ile ba tswa le hape moqosuwa wa ntlha o nentse a le tlisa phanga a thusa batho gore ba buletsela ke ka mo he morawa mo moqosuwa wa ntlha a ya koloing ya hae BMW a tswa ka rifle a thunya hanotsi udimo gore batho ba phatlalle gore ba gone ba o bulela tsela ba baleye le hape wa hlalosa gore mo diweapon tse ileng da fumanwa mabapi a molatona ba ile ba fumana rifle e notsi le diphanga tse pedi ke tsona fela tse ne ba di fumana le hape la hlalosa gore ha kgono a rantsa gore ke rifle e feng e ileng ya sebediswa ko ketsahalong eo le hape wa hlalosa gore yena ka lepodisa o ile wa nka sethunya se ileng sa fumana gore ba lo se etsa ballistic report PPE e etswang ke batho ba sebetsang ka hlahloba dithunya le hape ba hlalosa gore sethunya se replica a se toy kgotsa se sethunya sa bapala le hape wa hlalosa gore sethunya sa bapala kgotsa replica enena le haina barele kgotsa mo kulong e kena teng kgotsa trailer mo sebedisa mothunya sethunya teng le hape wa hlalosa gore sethunya se a se boneng ko video hana bonnete ba gore ke sona se tshwereng ke maponisa kgotsa se sona le hape wa hlalosa gore sethunya se seng sa bobedi se leng sa sebediswa ba se fumana le hape ba ile ba etsa dipatlisiso ba fumana gore sethunya seo se na le serial number a wa tswela pele a bala report mabapi a sethunya seo a se hlalosa gore ke sa mofuta o jwang le hape mosekisa ba mo botsa gore sethunya se ba se fumaneng ana se ka lematsa motho ba hlalosa gore e se ka mo lematsa ha baneng o haufi le motho ya sethunya le hape o ka etsala gore motho a lahlehelwe ke o bona kgotsa a be sefofu ha baneng ba sethunya pela mahlo a hae a le gaufi le gapa ba hlalosa gore mabapi a dilo tse ba sa mbotsang tsona a hlalosa gore dikoloi tse pedi e ntshuleseo ene siyo ko Katlehong police station ha ena a ne a fihla le hape ba hlalosa gore bona le bapaki ba bang ba ile ba bona ketsahalo ba ne ba supa ka sethunya ke moqosuwa wa ntlha le hape ha dira dipatlisiso ile a fumana gore moqosuwa wa ntlha o na le dithunya tse pedi tse tlasa molao ke sene se bua ke mopatisi.
Thank you. Your Worship, I have not been handed the report, which is now before court. Whether the witness used one line of that report, it's before court now. We're entitled to a copy of that report now, not tomorrow, but now. And I've not yet been provided with that copy. I have said, if you dispute the schedule, and if anybody comes there and witness at the state peril, because we will now get the opportunity to cross-examine. You have told this court that you visited the school. When was that? Date, time?
I can, through your worship, if I can be given a docket, then I can refer with dates there and time, your worship.
Bring it down.
Your worship, the date was the 16th of the 8th month, 2024.
16th August. What time, sir?
I cannot be exact, your worship, with the time, but that I can tell it's the date, your worship.
Was it in the morning or in the afternoon?
Your worship, I didn't look at my time, but it was in the afternoon.
Were you accompanied by any other person or you were alone?
I was alone here, Your Worship.
You told this court that you are from the regional office. Where is that office situated?
Your Worship, it's not regional office, it's a district office.
District office,
It's
yes.
situated in Clorkop. It's just between Kempton Park and Tembisa, Your Worship.
Cloroko.
Oh, my apology. My apology, Your Worship. Yeah, I was just answering the question, where am I based? I was saying I'm at the district office, Your Worship. It's in Clorkop, just between Tembisa and Kempton Park.
Do you know when this incident happened?
Yes, Your Worship.
Can you give us the date?
It was on the 5th, Your Worship, of the 8th month this year, Your Worship.
You say you were given a video by who?
Your Worship, I was never given a video. I've viewed the video, and thereafter I've called the expert to come and download it.
Where exactly where you viewed that video?
Right in the headmaster's office, Your Worship.
What did you see in that video?
Like I said, Your Worship, the most interesting part is when they leave the crime scene. There were people who were passing by that blocked the accused number one. No, let me not say accused number one. It was a black BMW. I don't know whose vehicle is that. There were people who were blocking accused number one to get into his vehicle. That's when he went in, opened the door, pulled another rifle. When accused number two was clearly seen carrying the other rifle, he fired one shot, he dispersed people, he got in the vehicle, and they drove off.
So the people were blocking the applicants from entering their vehicle.
Correct, yes.
Did you see anything inside the school on that video? What transpired?
Which side of the school, if I ask?
In the video, it shows you whatever it is.
Correct.
I'm saying inside the school.
Correct.
Wherever
Correct.
part of that.
People were just flying all over the schoolyard and inside the, between passage inside the school building, Your Worship.
There was no fight inside.
There was.
Right? Tell the court. Tell the
There was.
court.
I have explained that, Your Worship, to say accused number 3 was locked inside. It's the butler door in the passage. That in front of that door, there was chaos. It was fight. They were like, waving each other with pangas and rifles. And that's when he handed in the other panga for accused number 3 to forcefully open that door. And when they leave, there was like fight as well. But because they were in position of the rifle and pangas and they were armed, and other people were not armed, they managed to escape that situation. That's when he arrived at the gate, already there were people who blocked his vehicle, and he went inside, Your Worship, in that vehicle. That's where he pulled a vehicle. He fired one shot, managed to disperse people, and they got into different vehicles and they followed each other.
Accused number 3, locked inside.
Correct.
Did you inquire why was he locked inside?
The reason for him to be locked there, I spoke to Deputy Principal, Your Worship. He was saying he couldn't understand why one can force to take keys that belongs to him. Then he said to him, look, let's go inside, let me call the police and other family members to verify if surely indeed you are eligible to have these keys with you.
As a policeman, a seasoned policeman with 22 years of service, locking of a parent behind the butler, was it lawful?
Your Worship, there's no crime with that. The deputy principal never committed any crime. It was just to say, look, wait, let me understand your story. Why are you two guys fighting over the kids? And you should call the police and see how can we best sort out this issue. So there was no crime.
I have not talked about crime. I've said, is it lawful?
It's not unlawful.
It's not unlawful. Oh. Thank you, Your Worship. Yes, thank you, Your Worship. You have testified in this court to say that you have a report. Have you received this report? Your Worship, I just want to place it. I have not received the report. You said the report says that the rifle is a fire blank. Is that correct?
It's correct, Your Worship, but I wanted to say to you, the author of that document, if you want to go further and explain what is this, what is that.
No, I'm not interested in the author. I'm interested in what you are telling this court.
You are correct.
You are saying the rifle fire blanks.
According to the report, you are correct, Your Worship.
Does it require a license?
You should call the expert to come and explain that part, Your Worship.
Thank you.
It's not my line.
Thank you. No. Don't even go there. Don't even go there. You have talked about the second rifle that is still missing. Can we have that video to see that indeed there is such a rifle?
Correct, Your Worship. If given time, that will be available.
Is that rifle identical to the one you have now?
I don't understand the question, Your Worship.
I'm asking a simple question. Is the rifle that you're saying you are still looking for it identical to the one that you have now, that you have a report on?
I cannot say, Your Worship. I cannot be able to answer that question, Your Worship.
What color was the vehicle where you say the accused went to
It looks black on the footage, Your Worship.
It looks back. What will you say if I tell you there was no black car in that area?
That's your view.
Thank you. You have told this court that firing a blank at close range, it can blind a person.
Correct.
How did you come to the conclusion that a blank firing weapon, or as you say it, is a Schedule 5?
Your Worship, he like this word blank. A replica, Your Worship, is not a toy.
What is it?
It's an imitation of a firearm.
Imitation
It's an imitation.
of a firearm.
You took this thing and make something that looks like this, exactly like this one, with parts on it that some are original, some are not original.
Is it a firearm?
It is.
Your Worship, I have no further question. The witness is contradicting himself. One time he says it's a imitation. Then he says it's a firearm. Imitation cannot be what it's supposed to be.
Thank you, Your Worship. I have a few questions. I will not be long. I'll be very short, very short. Already, Advocate Dlamini has asked some questions that were important. I just want clarity, Mr. Ngwepe, to clarify a few things. Mr. Ngwepe, you said you saw everything on a CCTV, right?
Correct, Your Worship.
What was the quality of the CCTV? Because the quality of the CCTV normally is not of high resolution.
It's clear. It's very clear. I'm not sure whether should I use the words the quality was good or what, but it's clear. You can see.
You said when you were answering the issue of a BMW, you said it's a black. It looks like a black car. Does that mean that the video was not clear to say it's a black car, to say it looks like?
You know, in a video, sometimes something gray can look black. That's what I'm saying. It looks like a black.
So you are agreeing that the CCTV was not clear?
It is clear.
It is clear, but it looks like, so it means it's not clear.
Let me reiterate that question. It's a black BMW.
So if you are not able to tell who owned the BMW or the registration of the BMW being so big, how will you be able to tell if the gun on the video is a replica or is not?
Look, the registration number on the vehicle, on the footage itself, does not, actually the footage does not reflect the registration number. And I could not, I didn't find the vehicle on arrival. If I should, I will be saying before this honorable court, the vehicle belongs to, and the color is the make and model of the vehicle.
Okay, let's talk about the replica. You said the replica can blindfold a person if it's shot on a close range.
Correct.
But do you know that the reason is called a replica or a blank gun is because it does not release the projectile of a bullet. it only make a sound.
This one, before court releases whatever you're talking about.
It is not true. You are misleading the court when you say a replica gun can release a fire or anything. A replica gun, its barrel is closed. The only thing that it does is to release a sound. It does not even need an expert to know what is the meaning of a blank gun. If then it can release a bullet or a fire, it's no longer a blank gun. It should be something else.
Your Worship, I don't agree, Your Worship.
Okay. Now, when you say you are not able to tell the difference if it's a replica or not, but yet you are able to tell what impact it can give, how much of knowledge do you have with the gun to say you are able to tell what's the impact of the replica gun, but yet you are not able to tell if it is real or not real?
You know, there was big smoke after he pulled the trigger there. That is a sign that it releases something on it. It's not close as you are saying.
Okay, let me put it to you, Mr. Ngwape, that there was only one gun which was handed over to the police station, which you are in possession of, and which is a replica, that we have submitted its purchase receipt. And equally so, this replica gun, it is written on it that this is not an actual gun. So the video you are talking about, if really there is a video, you should have brought it here. A video should not be described, it must be seen. There is a TV there that it could be played, and we see that video, and we are able to mark perhaps the gun that you are talking about and the gun that you have, and maybe look at the similarities. But so far, you cannot deprive a freedom of a person on described video that you do not produce in court. Thank you, Your Worship.
Can I? Yes, Your Worship. Your Worship, we have the footage. So, it cannot be that we don't have it now, that we don't have the footage. We have footage that definitely depict what I'm talking about.
Nothing. Copies are not made of. This is
No, it must be kept in the. This is not a trial. It must be kept in the docket. Yes. So I will hand it in onto the record once the defense has a copy. Do you have a copy, Mr. Dlamini?
No, I don't have.
Okay. All right. Time is 4 o'clock. To adjourn for tomorrow. Oh, I'm not sure.
As the court places.
tomorrow she come.
Where are you tomorrow, Mr. Vidagaza?
How did you have it?
Yeah, you've got colleagues. They'll go. Miss Mudamsho will go to district court number 1. That's fine.
They postponed, and she indicated that she will not be doing any trials in my court.
See, I don't want to get involved in state issues now. So, what was your application now?
What?
What's your application? You're saying.
Yes, the state request that the matter not be postponed tomorrow. The only time, even today, I had to postpone trials. So the only time I will not be having trials is the 20th or the 23rd.
No. No, Mr. Vegazi. Your colleagues must come and assist you with your court. Let us get on with the business of the day. I think you're aware that I'm no longer in the criminal section. So I don't know. You need to arrange and find out and see what needs to be done.
Yes, the witness wishes to say something.
Yes, Mr. Mwepe? No, but you're done, remember. You're done. You can stand down. Your testimony is done. We just need to finish the copy of the said ballistic report. So, Mr. Mwepe, I'm going to excuse you. You're done with the testimony. Unless...
Nevertheless, tomorrow I'm not available and Friday.
Tomorrow's what? It's Thursday?
Yes.
Slamini?
Your Worship, that's not proper. I have said it and I continue saying it. The state is playing games with the life of the accused. Your Worship, tomorrow is the day the court has decided tomorrow, so will be. I will postpone my cases in other court for tomorrow and or ask my colleagues to go to deal with those cases. This court has listened to this and this court has decided tomorrow. Your Worship, they brought 3 prosecutors for accuser. Now they are telling us what they can't swap. It's not proper, Your Worship. That creates a problem. That interferes with the constitutional right of the accused. They first started by saying we should go deal with the new facts. When we're raising a point of law, Your Worship, and up to now, they have not shown what is required to be shown before this court. We are not going to play the game, Your Worship, continue playing this game. It is defeating the ends of justice. Thank you, Your Worship.
I really believe that if the court can do its court role in another section of this building and come and attend to this matter, if the defense can sort out the logistical issues of postponing other cases in other courts, then surely the state in this building can assist Mr. Vilakazi. Mr. Vilakazi, you've got numerous colleagues. I don't even want to mention them. They are in this building. They can assist you in your court of District Court number 1. I really want to finalize this case. I want to. We need to get progress. You had time from last week, the 2nd of September. Today is the 11th of September. And I want to also reiterate that the senior, your senior, Mr. Ramavuya, expressly stated on Monday that whatever happens to the recusal application, this matter will proceed. So let us proceed. We have started proceeding. So please get the assistance from your colleagues to come to assist you more so. You are faced with this matter. You assist with this matter. So let's see. I want to help you. I want to assist the defense. I want to assist you as well.
Yes, so she understand.
Yes.
But not tomorrow.
Let's see let's see what happens tomorrow.
Not tomorrow.
Gentlemen, please stand. Your case is rolled over to tomorrow, the 12th of September. Applicant 1 and 2 remain in custody. We will see then what happens tomorrow. The state must then get their house in order tomorrow, 12th September. Thank you.
As the court blesses.
Tomorrow, before we proceed with this case, Mr. Bonyani, you will summarize the remaining part. Hold it, just put it together. If you're going to leave this building, please leave quietly. The court is still sitting.